On the cases that you referred us to relating to Section 12, can I ask you to specifically give me references where they deal with the actual meaning of trial as envisaged in Section 12? If they do say trial as contemplated in Section 12 includes motion proceedings.
Yes, so firstly, the question of the meaning of trial. In other words, the argument we have here, whether or not the trial is the same as Section 35.3, that you will find at paragraph 14 of Nel versus Roe. It's clear there.
I'm sorry, that I understand. A trial cannot be a trial only if it caters for the rights in Section 35. You can still have a trial that does not cater for that. What I'm interested in is the interpretation that says, when Section 12 says you have a right not to be detained without a trial,
yes,
it means you have a right. The word trial includes if you have a hearing in motion proceedings,
yes,
that would constitute a trial.
yes, no, yes. That's what is in paragraph 24 and 25 of Faki in the majority judgment. That's where, in fact, in paragraph 25, and in interpreting of the procedural aspect, it seems to me entirely appropriate to regard the position of a respondent in punitive committal proceedings as closely analogous to that of an accused, and therefore determining whether the relief can be granted violating section to the respondent such substantially similar protections as appropriate to motion proceedings.
You see, it does describe them differently, not as a trial. It seems to me the concern of the court there, the focus was whether or not the procedure or process had the fair right, fair trial right safeguards, as opposed to saying this, which is what we know as lawyers, we know that motion proceedings do not constitute a trial normally. Now, if the court were to say the word trial does not carry its normal meaning as used in Section 12, in Section 12, it also includes motion proceedings. I would expect it to say it explicitly, because motion proceedings are not a trial.
Yes, well, Justice Jafta, firstly, just to go back to paragraph 14 of Nel versus Roe and paragraph 67 of DeLange versus Smarts. Nel versus Roe is clear. The trial envisaged by this right does not, in my view, in all circumstances, require a procedure which duplicates all the requirements and safeguards embodied in Section 25.3 of the Constitution. But what's the positive content? In most cases, it will require the interposition of an impartial entity, independent of the executive and the legislature, to act as arbiter between the individual and the state. And you then go to...
I still understand that. I understand that. I have no quibble with it. But I still understand it to mean it must be a trial. You don't have to say it is a trial only because you can tick the boxes in all boxes in relation to Section 35.
Yes.
Some of those requirements in Section 35 may not be there, but it must still be a trial.
Yes, but Justice Jafta, but that question is, in our respectful submission, completely answered by evaluating whether or not the motion procedure for contempt breaches Section 12, which is what FACI is about. And FACI says it's perfectly compatible with Section 12. And Section 12 is the trial right. In fact, the minimum requirement for a trial, according to Nel versus Rule, the minimum requirement is an imposition of an impartial entity independent of the executive. And you can look at this trial issue. When I looked at these cases, you look at this trial issue as a spectrum. On the one side of the spectrum is a summary procedure, a person in FACI committing contempt. That is a trial, which in some instances has been found to be lawful. In the middle is motion court procedure, where there is a full exchange of pleadings, where there is no exclusion of oral evidence if the respondent, by the way, which may even, in fact, even give them greater protections, where a respondent may ask for a matter to oral evidence. And then on the extreme end of is then witnesses giving evidence. But those three are themselves manifestations of the trial, from summary procedure to a full-blown sitting with witnesses giving evidence. But that's all a trial.
Well, I thought, Mr. Ngcukaitobi, and correct me if I'm wrong, I thought if we are called upon to interpret what Section 12(1)(b) means,
Yes.
we have as a starting point to look at the language of the section and determine the content and scope of the right in relation to that language. And if we do that, we have to say, and it may well be that this is what it means. We have to say, trial as contemplated there, having determined, includes motion proceedings.
Yes.
If we do that.
Yes, there's a different way of putting the same proposition, Justice Chair. Firstly, let me answer the one question about what question is before the court. That is not the question before the court. The question before the court is examining an error, a basis to re-enter the debate. And I have shown now that you have no basis to re-enter the debate. So the narrow question is, do we have the basis to re-enter the debate? The answer is no. Then you've asked me the question as to how, in fact, you should approach the question of interpreting the trial. So I say there is a different way of putting the same proposition. And that way of putting the same proposition is a motion court process for contempt an infringement of Section 12? That, in fact, is the pertinent question. And if you
but the section uses the word trial. No one would be detained without a trial. You have a right not to be detained without a trial, meaning you can be detained if there was a trial, isn't it?
Yes, no doubt. I accept that entirely. What the point of simply being in court is your oath twice. Machabeng and Peko, the SCA is the most exhaustive and the most learned. In fact, after the SCA is probably this judgment by Justice Khampempe that is the most learned on the topic, because you examine the textual violations, you ultimately come to the conclusion. And so if you were to drill this thing down, remember in Nel versus Roux and in the Smarts versus the Lange, those were instances about what to do with a witness who is recalcitrant from testifying and whether or not you could arrest them summarily. And the finding there was you can, as long as the summary arrest is not done by, I think it was a body of creditors in the Nel and Roux case, as long as at the base minimum, that is done by the judiciary. So if you look at what Justice Ackerman ultimately says in the finding, he says the section is unconstitutional because it does not interpose the judiciary. So the focus of the section is always, do you have an independent judiciary making the determination? The language trial is seen in a spectrum from summary to motion to what we call a trial, which is witnesses giving evidence. But all of those are mechanisms of giving effect to section 12. But motion for contempt, you have said it twice, it's perfectly constitutional under section 12. And that is what has been held in Faki. So I'm afraid you will have to substantially revisit your authorities if you are to find that motion court proceedings are inappropriate for contempt proceedings.
Well, I'm not quite sure about that because my recollection of Pekwe and Machaveng, for example, is the distinction that is drawn between civil contempt and criminal contempt. And civil contempt, as I understand it, is a process which does not lead to a conviction and a criminal penalty. It's a process that leads to some civil remedies. So that distinction was drawn. Here, we're dealing with a criminal contempt. And that is a process that leads to a conviction and sentence. So I'm not sure whether you are right to say we will have to revisit our decisions. You may be right, of course, but you see, what I have not picked up, Mr. Ngcukaitobi, in the short time that I had in preparing for this hearing was to pick up a case that really says what is meant by a trial is any judicial process. If it's a process that is run by a court, it constitutes a trial for purposes of Section 12. If that is what we are saying, I think we need to substantiate why we're saying that. I understand a proposition that says, no, don't get confused. If Section 12 says a trial, it doesn't mean a trial that will have to meet all the requirements of Section 35.
Yes.
That I have no quibble with that proposition.
Yes. Well, Justice Jafta, that's enough for me to succeed. That you simply reject the idea that underlies the application, which has been rejected in this court. So that would be enough. The question as to whether or not trial in its full manifestation would include a summary procedure, motion court procedure, can be parked for another day. What is enough for today is simply you to be satisfied that on existing authorities, only 2 points you should be satisfied with. On existing authorities, the Section 35(3) protections have not been imported full scale.
Yes.
Secondly, motion court proceedings have been approved as being appropriate and not in breach of Section 12. Those are the only 2 things you have to be satisfied with. Yes. The debate we've been having is an interesting debate, but it is not a bar to a judgment by yourself, not you personally, but by the court in favor of the respondent.
Yes. Lastly, what troubles me, and it may not also be relevant for the determination of the issues that you have just mentioned. What troubles me is this in relation to the applicability of Section 35. As I see it, it was open to the Commission to go and lay a criminal charge when Mr. Zuma did not comply with the court order? Or am I wrong?
Yes, Justice Jafta, I mean, I know for sure that it was open to lay a criminal charge when he didn't comply with the summons. But when he didn't comply with the court order, the contempt is enforced through a civil contempt. You bring an application to court and you compel him to comply.
Well, would the process suggested in the De Beer matter not lead to the laying of a charge?
No, Justice Jafta, we must remember that De Beer is a substantially different case to what we are dealing with. De Beer is closer to S versus Mamabolo. Because De Beer is not a case where you have issued an order in which a respondent refuses to comply with. De Beer is a case where a respondent, in correspondence to the registrar, impugns the court. But there is no order against De Beer to do something which he then resists. In the same way as what had happened in Mamabolo.
Yeah.
In Mamabolo, what was then recommended was a charge to be laid with the NPA or with the police rather. And the same thing in De Beer. But what we are dealing with here is a person who refuses or resists explicitly, openly, brazenly to comply with a court order. That process, as pointed out by Justice Cameron, would simply not be conducive to the proper administration of justice if the remedy of contempt by motion, because we must remember that this remedy, I know that we have been criticized by Mr. Mpofu that there is a deputy chief justice who's a member of this court and he has used senior counsel to bring a contempt directly to the constitutional court. Quite frankly, I don't know where that enters into the equation. But you must remember that what is crucial about this remedy of civil contempt is an individual who has been successful in court but is facing a recalcitrant respondent. So Justice Cameron says it must remain open to them to come to court and to compel compliance, failing which, as pointed out in Machabeng, to sometimes as an alternative, sometimes as the primary relief to ensure their incarceration. So I'm not sure that it is entirely accurate that we were precluded from coming to court to seek the incarceration. I think in fact it was the primary relief in the head.
No. I'm not exploring that. I'm not saying, my understanding of it, and it may be wrong, is that if it is a crime, if we accept, if we move from the premise that contempt of court is a crime, whether one has disobeyed a court order or has done some other form of contempt, they have committed a crime. Hence, we have this whole notion of a conviction followed by a penalty. Am I wrong?
Yes, no, I get your point. I mean, in those circumstances, I think that is whether it was appropriate for us to approach the court on proceedings seeking punishment.
No,
and I think the answer to that is, I mean, the answer to that is in Pegor.
I accept that, Mr. Ngcukaitobi. My concern was lying in this. There are two options available to a litigant who has an order made in their favor and it is not carried out, as I see it, is either you go to lay a charge or you pursue contempt of court proceedings as the commission has done. Am I right?
Yes, you may be right. We'll have to look at the first part of the case because I cannot at this point in time confidently give you the answer. But let us assume that's correct to facilitate the debate.
Yes. The concern that I have then is in relation to Section 35, it seems to me that for the person, the contemner, who would have enjoyed the protections in Section 35 had a criminal charge been laid, somehow does not enjoy the same protections if the route of civil proceedings is followed.
No, that's true. I mean, but that's water under the bridge. That debate has been had. It's been found, and this is the point, since 1996, it's been found that you can actually bring a civil contempt, and it's been found that civil contempt need not duplicate the Section 35(3) rights. And it's been found that is constitutional. And there are strong public interest reasons for that, which have to do with the proper administration of justice. These are all set out in Faki. They are all endorsed in both Machabeng and in Pego. They say it's much better to have a functioning judicial system, and we need the mechanism of contempt in order to keep the judicial system functioning.
So what is it a case of the means, or rather the end justifying the means?
It is a question that this topic that we are debating has been exhaustively discussed. And it has ultimately been concluded that the civil contempt process is compatible with the Constitution. If we had adopted an approach that is not compatible, that would be a different debate.
Finally, Mr. Ngcukaitobi, as I understand it, lawyers have different understandings of what civil contempt means and what can be granted in a civil contempt. There are those of us who believe that you can get a conviction and a sentence in a civil contempt. Some of us believe that you can't do that. You can get other remedies which are civil in nature in civil contempt. But I heard your argument. Thank you.
Well, I mean, the one thing that is unique about a contempt, it is one of the few crimes that can be purged. You know, you cannot purge murder. You cannot purge theft, but you can purge a contempt.
Yes.
And that, in fact, is the last point I should be making.
Thank you.